Good morning, afternoon, whatever it is for you. Not legal advice. Like, subscribe, share, comment. I am a professional pianist, as you could tell. I'm going to talk about two things today, GTII and an update, and an update on MMTLP, also an update. Like, subscribe, share, comment. If you ask questions, I'll try to respond. If you show your pets, please state that. I'm happy about that. I in particularly like and have big dogs, so big fan of big dogs. So before I start and talk about GTII and bring you up to date where I am since the last time we spoke about GTII, three quickies, since this seems to be the topic. Lobsters are greedy. They never give anything to charity. They're just shellfish. The pleasure is all mine, said the greedy hedonist. Think about that one. And last but not least, Canadians are greedy. Give them an inch and they'll ask for 2.54 centimeters. Anyway, moving on to GTII. My goal here is not to kill, and I've said it many times. I've spoken with many people about this also, and they understand the dilemma, but also now that the 10K is public, there's no way of getting around it. But my goal is not to kill GTII. Despite what appears to be obscene management. I've not gone to the SEC or DOJ or anything like that. However, just looking at the 10K and whenever I hear from people who contact me, eventually somebody will, and I'm shocked that senior management doesn't take that to heart, or maybe they are taking that to heart. To those who are playing for the squeeze, and I know there's a lot of people out there, they're in GTII because of the squeeze, the Alpine squeeze. And I checked this morning, I think on Friday, actually, I checked. There's no ruling on the appeal in DC, so that there's an appeal pending in DC with regard to the attempted expedited expulsion of Alpine. That ruling should come out any time now, and I'll update you when it comes out. There'll be some appeal process after that, even if they're allowed to go forward, and it would be allowed to conduct a disciplinary hearing to expel them. Then there would be some appeal. So it's still down the road. Additionally, there was a disciplinary hearing that was taken in Utah by the NSCC and DTCC, where they tried to remove Alpine from those systems. Those apparently were ongoing, but we don't have a final determination. Again, after that, there would still be an appeal process. So if it requires the actual expulsion of GTII to get a squeeze, that'll still be some time. But maybe just a negative ruling in one of these cases against Alpine might be sufficient in and of itself to encourage movement on the stock. But I don't know. And what management is doing then will have little influence other than one particular aspect. So if you're just playing the squeeze, then you're playing the squeeze. The problem that existing management has shown based upon the 10K is that they went from 260 million to 370 million outstanding shares in 2023. So they diluted approximately 45% of value, of shareholder value. Those shares were distributed, seem like willy-nilly, to directors, foundations, etc. Seem to be at grossly, I put that in quotation marks, grossly excessive amounts compared to prior years. So a lot of people believe, based on what I've spoken about, that the mere departure of senior management will, in and of itself, cause a positive impact on the stock, because people will believe if these jokers are gone, then the new management will do something, because, again, all kinds of opportunities have been addressed just to me, let alone management, and they all have indicated a dislike for dealing with management, and that management really had no intention of closing any deal. And if you look at the 10K, there are no deals that have generated any revenue for GTII in 22 and 23, and I believe so far in 2024, and no explanation from management in any respect why that is. None. You would think that that would be something. So somebody contacted me with a potential interest in pursuing a deal with GTII, and this was somebody new, and this is since my last video, and they were in the biotech arena. However, when they read the 10K, they grew concerned and they were apprehensive about going forward and doing a deal with GTII, current management. Again, I keep on referencing current management because I believe, and I again strongly believe, and I'm still a long shareholder, that once current management is gone, that new management will be able to facilitate some acquisition that generates revenue. Yeah, it's not hard to beat zero. So this person who expressed reservations about doing anything after seeing the 10K, he referenced, we talked about it, and some of the things that came up were the excessive compensation to leadership. Remember, David Reichman pays himself $600,000. Some of it deferred, gets a whole bunch of shares, is on a stock sale plan. We have no idea reimbursement of expenses, how that's taken. But there's quite a bit of, seems to be quite a bit of compensation going for very little productivity. And but anyway, that's that part. Second part is the dilution, referencing the dilution from 22 to 23. Again, why would you need to dilute so much if you're doing nothing? Again, no revenue generated in all of 23. Issues about obviously the downlisting, and I'll reference that again at the OTC. Issues about the distribution of approximately 80 million shares in 2023. So 55 million approximately to directors for purported past compensation, 15 to 20 million for foundations, other compensation. It appears to be over 80 million shares just handed out willy-nilly. Some might suspect that somebody decided, although they were in the side of shareholders for some period of time, let's say 20 years, year 21, if you looked at the 10K, you might think, wow, their intentions changed and they're no longer out for the interests of shareholders. They're out for their own personal interests. And that's just what the 10K says. The distribution to charitable foundations when the company has got zero income. How did that benefit management? This is what the person who I spoke to, their reservations about the 10K. A lot of those mirror what I've said. A increase in the net loss by 700%, something on the order of like $13 million to $87 million loss, zero revenue. That's compared to 2022. So you go from 13 million loss to $88 million loss, or approximately, with no revenue. Makes no sense. It wonders, it causes people to be concerned about the propriety of those actions. The excessive use of cash. Again, they spent $400,000 approximately in operations in 2022. In 2023, again, generating zero. They spent $4.4 million. Was that cash used or misused or misappropriated? Again, no explanation as to any of these items. Many who have contacted me are pissed at the CEO. I mean, really pissed at the CEO. Someone else contacted me and said they had a negative experience trying to get a deal done and question why that the deals that are referenced in the 10K, that closed apparently, why do they not generate any revenue? Again, someone could be good for 15 years and then be a thief on year 16, and both could be true. And we don't know what happened here because management has given us no inkling of what is going on here. They have not responded to zero of my inquiries, and I'll bring you up to date in that respect. So as a result of this, and I filed a lawsuit in California, that's early on, but I met with Nevada counsel because GTII is established in Nevada, subject to Nevada law, and they have an office theoretically in New York, although they don't have an office in New York. So I met with Nevada counsel, and we're meeting again, I think Monday afternoon Pacific time at some point, and we're meeting with a third party also to further discuss options. So what can we do directly in Nevada against GTII. And what we discussed, and I'm just be open about it because it's going to happen or it's not going to happen. What we discussed was, what can we do in Nevada to get rid of the board, get rid of management, and have this company move forward? What we talked about is you could pursue a proxy fight where you basically have a vote and try to vote out the board. That's possible. You could have a lawsuit against the board for breach of fiduciary duty, where you could sue the directors for what appears to be looting and other questionable activity in Nevada. Perhaps you could get a receiver appointed in Nevada to take over the operations of GTII. And again, the reason why it would be Nevada, because it's based in Nevada. New York would be another option, but the incorporation is Nevada. I sued in California because I'm in California and I can't pursue anything outside of California, and because the CEO resides in Southern California, notwithstanding the fact, and just another point, in the 10K it says he's a resident of New York, but I think he purports to everybody else that he lives in Southern California, and I believe he lives in Southern California. That's why I sued him in Southern California, but my preference would be Nevada, and that's why I met with Nevada Council. And after our next meeting, I'll be able to kind of update you what the options are. But there are particular legal actions we can take, probably the proxy fight and perhaps maybe an ex parte. In other words, going in immediately for a receiver are possibilities, but I will know more on Monday about that. And I also found out that there might be another, and so independent of me and my meeting with the Nevada attorney, there may be another Nevada attorney who is either engaged in or about to engage in litigation against GTII. I don't know who that is, but I hope to find out. And if I find out, of course, I will contact that person and find out what their interest is. And again, like I said, it's just a matter of time. That 10K was so obscene that some shareholder is going to be so offended they're going to pursue something. And that's kind of one of the reasons in my emails I indicate that this stuff eventually will be out of my control, because it will be out of my control. I've tried to give management off ramps multiple times, but they're so warped. Their view is so warped, they just don't get it. So I will be meeting again with Nevada Council and a third party on Monday. Hopefully have more information from there, and then maybe perhaps a recommendation after that also, depending on where it goes. I continue to reach out to GTII. So since the last video I did, since April 18th, I probably had a dozen emails. That's emails where I'm including both attorneys, David Reichman, Kathy Griffin, and Luke Rabari. They're all included. I have not received any response. So I've asked about, and obviously I've asked for an explanation, because doesn't that 10K deserve some form of explanation? I reaffirmed that all my stuff would be public, that I am still offering them an off-ramp to get out. I questioned some of the documentation about the dividend. So the dividend apparently is going to be available April 29th, theoretically. But there may have been an error made in the documentation. At least that's what Fidelity contends. And counsel for GTI apparently mentioned that there may have been an incorrect box selected. So it might have reflected that GTII was a shell company. Even if it's not a shell company, if it is listed as one any quarter, it's dealt with as a shell company. And Fidelity referenced that was a problem. And they also referenced that there was an earlier issue that made them, and again, this is not my conversation with Fidelity, this is somebody else relating their conversation, but Fidelity seemed to indicate there was some other thing about GTII that concerned them, that was going to prohibit them from honoring the dividend. And I guess there's 31 million approximately dividend shares. So we'll have to see on the 29th if that's honored. Or was there a mistake in the documentation? Was it done on purpose? I don't know. Remember that the dividend was offered at an awkward time. So April 10th Going back, April 10th of 2023, there's a notice from the OTC that you get kicked down to pink sheet level. The next day, April 11th. April 11th comes, they're kicked down to the lower level, which excludes them from certain capital structures. Certain people can't buy them. April 23rd, I think it's the 23rd, that's when the special dividend is released. Is that done to kind of take shade or offer shade from the downlisting that hadn't been really discussed? One wonders, because the notice about the downlisting, which didn't describe really what had happened, but was a very cryptic note, didn't come out till May 3rd after the special dividend. So it's interesting, the timing of the special dividend and the timing of the first disclosure, even though it was inadequate, of the downlisting occurred after that. So we don't know if it was done properly at that time. I know there was an opinion letter issued. There was some question about the date of the opinion letter, but that's kind of it. So there's an issue about the opinion letter and the dividend. We'll have to see how that plays out. I asked if anyone from the SEC had contacted anyone from GTII. I asked to see the corporate documents. I asked for a reply. I indicated that, at some point in time, this can be out of my hands because others are going to be involved, and I'm trying to give them an out and protect everybody. But one thing that came up, and I addressed that recently, and again, not responded to, is another person contacted me, and they were speculating about the downlisting, and they were wondering, because they did a bunch of research and they discovered that in 2021, and let's go back to the downlisting. So that note about the OTC downlisting says that this is ongoing. So it wasn't the first time the issue had been brought to their attention. And obviously the OTC was pissed by that time, because the last notice on April 10th, they take action the next day. So it says ongoing. So it suggests that probably the OTC made many inquiries, no response, or an inadequate response from GTII, and they never corrected it. And they left shareholders kind of in the lurch. Why, we don't know. But somebody was speculating, and they contacted me and they threw this out, that there's a related trust in 2021 that bought real estate in Northern California, and they were speculating that perhaps that related to an improper distribution and sale of GTI stock, which was in itself, which caused the downlisting, because the downlisting says there was inaccuracies with regard to insider transactions and beneficial ownership of the stock. So it suggests that perhaps there was a sale of stock that had questionable ownership, or that the use of the stock had questionable ownership, or that there was a concern about insider transactions that was not properly explained and has not been explained to this date by management. And so this person was speculating that this piece of property might be reflective of this improper trading. It wasn't corrected, perhaps because management didn't want to disclose the transactions that led to the purchase of this property. So some have suggested that that might be criminal behavior on the part of senior management. And perhaps, I don't know, because management hasn't addressed it. And you would think that management knew that the 10K would be closely scrutinized, because I was public about it, for the past few months, and they haven't addressed it in one respect. How come no explanation of the obscene numbers? Could it be that there's possible criminal investigation, or an ongoing criminal investigation, or concerns that an ongoing or future criminal investigation might occur? And maybe that's why they have not responded. I don't know. I don't know if one exists. I don't know if one in the future exists, but there are so many points of that 10K that would cause any reasonable human being concern. All my contacts with GTII have been with a shareholder, which I continue to do. The writing is on the wall, one way or the other. Whether I exposed it first or not, and others have talked about it, I'm sure, someone I believe voluntarily or in a fight is going to bring management down and out. When that occurs, that alone will be a positive shock for GTII, the stock, not financial advice. I really believe, again, getting rid of this particular group of managers that I don't think at this time, notwithstanding whatever they did in the past, are not operating in the best faith of shareholders. They need to be removed. Everyone I've spoken with has been shocked at how GTII management has not responded. After next week's meetings, we'll see, and I'll report. And maybe the Trump social stuff might help GTI. We'll report further on that. Now I'm going to quickly talk about MMTLP. So I reached out to Devin Nunes and offered, he's the CEO of, I guess, the Trump social network, former congressperson in California. Reached out to him, said basically, I'm involved in multiple tickers, happy to assist in the counterfeiting issues that you are now handling. You know, he'll either get back to me or not, but I've offered my assistance. Obviously, I think that's helpful for MMTLP and any shorted stock. And I know that a letter that was sent out in December, I think, that was signed by Congress people, sent to the SEC and FINRA, was attached as an exhibit or as part of one of the letters that was submitted by Nunes. And I've also attached that and am submitting that to my arbiters as evidence to be used in this case. So if you recall, I'm in arbitration with Fidelity. We have a hearing on April 30th to go over discovery issues. On April 25th, I sued my arbiter, the main arbiter, the one who's the decision maker, for declaratory relief, basically asserting that I don't think he deserves to get paid from me. Wasn't challenging the arbitration, and he's not a party to any of the litigation that I have been involved with. So I sued in the state court. He's been served or subserved in that the address apparently he gave is not his real address, but so be it. And FINRA has been made aware of the fact that I have sued him. Now, he's an arbiter and I've sued him, so some might say that creates a direct conflict of interest and he cannot continue to operate as the lead arbiter. And as I've indicated, and we'll see, because that's right in front of the arbiter, and I'm going to this weekend file another motion to recuse the arbiter, to remove him based on that. But it'll be interesting to see how FINRA handles this. It'll also be interesting to see how the director, who has not responded to a prior request about bias of this, how he responds. I'm going to file something and request for subpoenas to be issued. If you followed this, I've asked for documents, share accounts, whatever, all denied. And my basic issue with the ongoing arbiter, despite his age and his possible lack of abilities, is that every motion that has been filed has been denied, which in and of itself is no big deal, although I think they were all well taken, but not denied only, no hearing, no rationale, so no reasoning for the denial, and no reference that any of the claims were considered or the pleadings reviewed. So I have literally 20 claims in this arbitration, and I attach my federal court complaint, which is 35 pages long. So a non-litigator, this particular arbiter, without a hearing, without reviewing the complaint and claims, has made numerous rulings all against me and MMTLP shareholders. I question that. I've asked he be removed, etc. Eventually had enough. Just not going to tolerate it. If you've seen Animal House, there's a scene where Kevin Bacon is in his fraternity, and he's getting a not so pleasant experience. So I don't want another. So look back at Animal House, look at the scene with Kevin Bacon at the fraternity, and you'll know what I'm referring to. I don't want to pay for someone to rip me off. And I think this arbiter, it's my opinion, he's ripping me off. So we will see what happens. The pleadings were just filed. We have a hearing on 4:30. This arbiter theoretically would be handling that hearing, but there will be pleadings before the FINRA panel. And again, I'm kind of going through this so people have an understanding of what happens in an arbitration, because that's the remedy we get as consumers when we've been screwed, or we think we've been screwed by brokers. We can only arbitrate against that as to our account. And I've tried to illustrate to you the problems with that, the costs associated with that, and the lack of due process clearly that occurs. I will obviously keep everybody apprised what happens after the 30th of April, and I'll let you know what happens in terms of the director's ruling and whether Fidelity's counsel draws raises a storm. I would love Fidelity's counsel to go back to federal court and attack my complaint, and then I would have the opportunity to address why I was going after the arbiter. So filing documents will be filed this weekend. Trial date currently is the end of June. I think I mentioned, but if I didn't mention, Curtis and Berta are both witnesses who I will be calling besides myself. I don't know if I will need anybody else. That should be sufficient to cover the record. But I will also be subpoenaing various people, and we'll see if our great arbiters permit me to subpoena those people. They have to approve of that also. So covered GTII, again, still remain bullish as soon as these management types depart and we get taken care of the issues of the huge dilution that seems improper and impermissible. And MMTLP, so again, further recusal request of the arbiter, sued one of the arbiters. We're waiting for the director to rule. We have discovery issues pending, late June trial date, and that's where we stand. And hopefully we're going to see if the Trump social push helps MMTLP, and we'll go from there. Anyway, that's all. Talked a lot about a lot of stuff. Be well. Take care. See you Wednesday night with a live stream with Kirsten Shaughnessy. Look forward to it. Be well. Take care.